mayowe hapa, mkubwa wangu atatitimua. Lakini huyu jamaa kaka yetu mzee, kila siku porojo, kelele. Jambo ambalo liliwakera wengi wa Kenya na wabunge ni hili. Kila kuchao alikuwa anaamka, Mrima. Wewe ulikuwa naibu wa rais wa Mrima ama wewe naibu wa rais wa taifa la Kenya? Waelewa? Na yeyote ambaye atataka kuhudumu kama naibu wa rais, mimi singelipenda kuhudumu kama naibu wa rais, sababu mimi nimekuwa rais. Sitawahi taka kuhudumu kama naibu wa rais. Kama nataka kuhudumu lazima niwe rais. Lakini ikiwa wewe utapendelea kuhudumu kama naibu wa rais, na ikiwa wewe utakuwa naibu wa rais wangu, lazima ucheze chini. Ufuatilie basi mwelekeo ambao umeletwa na mkubwa.
Basi niulize kwa mtazamo wako, ni kipi ambacho pengine angefanya ajirudi nyuma? Maanake nafikiri kwa mwaka mzima huu malumbano yalikuwa yameshaanza. Kwa mtazamo wetu pengine... Wacha
nikukatiza hata kabla hujaenda mbele. Hakuna chochote ambacho angelifanya. Ni maumbile yake. Unajua kuna watu ambao dosari yao ni maumbile. Kwa mfano kama mimi, watu wanasema yule jamaa anapenda kuongea, ako na kiburi. Makosa si yako, ni maumbile yangu.
Naam.
Lakini so, maumbile yake ambayo yamemleta chini.
Bila shaka, lakini nafikiri kuna wakati ambapo unaangalia maumbile yako na unaangalia mtazamo wa Kenya kwa ujumla na kiongozi wako, unajirudi nyuma. Nikupe mfano kwamba nafikiri kwa baadhi yetu ambao tumemtazama kwa muda mrefu na matamshi yake, haswa Jumapili. Nafikiri kuna kisa ambacho kilitokea wakati rais akiwa katika siwezi kukumbuka ni kanisa gani, lakini ilikuwa ni matukio kanisani ambapo naibu rais alitarajiwa kuwa pale, na nafikiri ilikuwa sehemu moja kule Mlimani. Naibu rais akatangaza kwamba amekwenda kwengine na kwamba hakutarajiwa kufika kule kwa sababu shughuli zinaendelea na yuko sawa. Unahisi hapo ndipo nafikiri pengine rais alifika kikomo, akaona kwamba nafikiri hapa sasa ndio imefika mwisho. Maana kulikuwa na kiti chake pale, na haitokei namna hiyo kwamba ikiwapo naibu rais haji katika kikao cha rais, huwa matarajio yamepangwa tayari kwamba hastahili kuwa pale. Sasa sijui ni wajua sisi wanahabari.
Wacha nikukosoe. Waliomtimua mamlakani Rigathi Gachagua wanajulikana. Ni bunge, si rais Dr. William Samoei Ruto. So, yani kwamba jambo ambalo unaguzia liko na uhusiano wote kuhusu namna ambayo Rigathi
Gachagua. Lakini kwa nini nasema hivyo? Kwa sababu kuna mambo amefanya aonekane ni kama anajaribu kumwaibisha rais. Kwa mfano, ufike mahali useme sikupata ndege kwa wakati, kwa hivyo nikachelewa. Nikafika mahali nikapata kuna traffic kama kitu. Kuna mambo huwezi kumwambia bosi wako saa nyingine. Kweli ama?
Unajua mambo kama haya ni madogo na mimi na ndugu yangu hapa ni watu wakubwa. Hata tungeweza kuzungumzia maneno madogo kama sababu mwenyewe amesema yeye hana upungufu wa pesa, hana upungufu wa uwezo. Na mimi kwa mfano ukichukua gari ambalo nilipewa na serikali, sitaanza kupiga mayowe kwamba umechukua gari. Niko na gari yangu. Nimekuwa na magari kwa miaka karibu 25. Nitachukua gari na niende. Iko ulialikwa kwenda kanisani, habiri gari lako na uende. Na kama unataka kwenda na ndege, chukua ndege na uende. Na tuliona alivyohudumu Dr. William Samoei Ruto. Sisi tuliabiri na yeye mara kadhaa. Hata huyu jamaa alikuwa anaabiri. Hiyo ndege ilikuwa ya serikali ama ilikuwa ndege yake?
Ilikuwa laki.
Ilikuwa ndege yake. Basi jambo gani ambalo tunajadili?
Anakodisha kibinafsi.
Alikuwa na ndege yake. Kodisha ndege yako. Wewe ni naibu wa rais, uko na uwezo. Na hata kabla hujakuwa naibu wa rais ulikuwa na uwezo. Usije hapa kila siku malilio ambayo hayana msingi, ambayo yanaleta afisi yako chini. Na ni mambo kama hayo ambayo sisi tunayangalia, tunasema kwamba hapana, huyu afanani kama naibu wa rais, huyu afanani kama rais. Je, angelikuwa rais alafu mzunguko wake uwe tu mlima wa Kenya, tungedhulumiwa sana kama wa Kenya. Watizama.
No. Actually kuongezea ni kwamba kile kitu cha maana sana ambacho wakili Havi anasema ni kuna ule mtu ambaye maumbile yake inampea nafasi nzuri sana kuhudumu kama naibu wa rais, na kuna wale ambao wako na maumbile ambayo kuhudumu kama naibu wa rais hata siku moja hawawezi. Na jambo kubwa ni kwamba Rigathi Gachagua angepaswa kuelewa kazi yake kama naibu wa rais inamaanisha nini, na kwa mtazamo wangu hakuelewa kazi yake kama naibu wa rais inamaanisha nini. Na kama uko na ambition, kwa sababu tukiangalia rais wa sasa William Samoei Ruto, kwa wale ambao wanamjua vizuri na vile tumeangalia historia yake, wakati alikuwa naibu wa rais, alielewa kazi yake ya kuwa naibu wa rais na alielewa ambition yake ya kuwa rais inaanzia wapi na ataanzia wapi na atamaliza aje. Lakini anzia wapi na atamaliza aje. Lakini kwa huyu Rigathi Gachagua hakuelewa kazi yake kama naibu wa rais na hakuelewa hii ambition yake ya kukuwa rais wa Kenya itaanzia wapi na itaelekea wapi. Kwa sababu kama uko na, mimi kwa mtazamo wangu, kama niko na ile fikra ya kuwa rais, siwezi anza leo kwanza kutamka matamshi kwamba Kenya iko na hisa na kama hauna hisa kwa hii serikali hautakuwepo. Kwa sababu wakati itafika kwa kura, wale watu wa pande ile ingine wataniuliza, kwa hii serikali yako tuko na hisa kweli? So ni jambo ambalo wengi huwa tunasema, mimi kwangu ni ile maumbile yake hayakumpea nafasi kuelewa kazi yake na kuweza kutimiza ndoto yake.
Asante sana wakili Nelson Havi, wakili Joe Kalende. Kwa heshima ya mahakama, nafikiri kikao kiko karibu kuanza na nafikiri tutaelekea kule. Natoa shukrani za dhati kwa kuwa pamoja nasi katika kutufahamisha maelezo hayo. Nafikiri niwape ruhusa na nyinyi pia muweze kufuatilia matukio hayo kwengineko, lakini sisi tutakuwa tunaendelea kusikiliza mengi kutoka mahakama. Nasema asante sana wakili Nelson Havi, wakili Joe Kalende.
Asante.
E565 of 2024, Rigathi Gachagua versus state law.
My Lords, Your Ladyship, in petition number 565 of 2024, why we have two counsels standing.
Good morning, my Lord. Good morning, my Lord.
Good morning.
Principal Presiding Judge, my Lord Justice Murima, and my Lady Judge. I am standing as the Attorney General, and I was going to address you pursuant to Attorney General's Act Section 7, which provides that I take precedence. May I have your advice?
There is no objection. That is the correct position. Thank you.
So,
We will take the quorum.
yes, I was going to request you that we take the quorum first. I'm Dorcas Odora, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Githu Muigai, Senior Counsel, Shadrach Mose, the Solicitor General, Deputy Chief State Counsel,
Emmanuel who?
Emmanuel Bita.
Where is he? I'm present.
He's been swamped. And Charles Mutinda, Deputy State Counsel.
Present, my Lord. Present.
For the National Assembly, we have Eric Gumbo,
I'm present, my Lord.
Paul Nyamodi,
Present, my Lord.
and George Murugara.
Present, my Lord.
For the Speaker of the National Assembly, we have Benson Milimo,
Before you, my Lord.
Josephat
Just
Kuyoni.
too fast.
Oh, sorry.
You introduced Mr. Mugara for.
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo, Josephat Kuyoni.
Josephat who?
Kuyoni. Kuyoni. For the Senate, we have Professor Ojienda Tom, Senior Counsel.
Present.
Moni Mukele Edwin.
I'm present for that.
And Senator Hilary Sigei.
I am present. Money who?
Moni Mukele Edwin.
And Professor?
And Senator Hilary Sigei. That is for the Senate. For the Speaker of the Senate, we have Mercy Tanji and Peter Wanyama.
I'm present.
For Professor Kindiki, CS, and DP nominee, we have Mudomi Piankolu.
I'm present, my lord.
Moses Kosgei, and Ken Meli.
Present. My lords, your leadership, in petition 565 of 2024, may I, at the very outset, before I state counsel appearing for the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, and we will elaborate. But let the record show that counsel appearing for the Deputy President today before this honorable court appear under protest. As I say, the basis will be elaborated later. I appear, or waited for the record, I appear with my colleagues, Tom Acharya, Elisha Ongoya, Faith Waigua, Victor Swanya, Debo Wanjiru, Andrew Muge.
This we are recording the program. Faith Waigua,
Victor Swanya Ogeto, Debo Wanjiru, Andrew Muge, George Wandati, Mr. Sakim Pa, and John John.
Present, Lord.
My lords, your leadership, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether there are any other petition. I thank you.
we'll take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and 4 others versus the National Assembly and 5 others.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the respondent is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Just for the purposes of clarity, just we'll record the quorum fully.
Dorcas Odur appears the Attorney General. For the Attorney General is Professor Guy, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bitter, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel.
Well, ladies and gentlemen, brothers and sisters, we are following up the case. Seems like we have a glitch or technical problem, but we'll be back. Hopefully it will be back. Meanwhile, please like the video, share, subscribe, and all the good stuff. As we proceed, here it is. Dang it.
Hello, my name is Mary Oyeke.
Right.
I'm from the county of Homa Bay. Towards the end of 2019, I could feel a
All right, we're back. We're back. Sorry about that. Here's the
Your name, please. My name is Kibe Mungai. I thought I'd something to know. Kibe Mungai. I have here in this matter, my lord, with Senator Daniel Manso, Mr. Ndego Njiro, Honorable Jerry Maina, Ms. Jerry Maina, Mr. George Sankimpa, Mr. Andrew, Mr. Kibe. Yes, we are recording the record. Yes, can you start from Dan Manzo? Dan Hanzo, Mr. Ndegwa Njiro, present. Senator Honorable Jerry Maina, present. Mr. George Sankipa, present. Mr. Andrew Muge, Mr. Gachagua Ruta, Kenneth Matiba, who is on the way, and Professor Oga.
Professor Oga, present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Bengoya, petition number E015 of 2024, that appeared to have been filed on the same day
So you appear for which party?
We appear for the petitioners.
Keruboya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya in this E015. We will once again let the record capture and show that counsel appearing for the first interested party appear under protest. Counsel are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigua, Victor Soanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what point? My Lord?
From yourself.
Appropriate time, we will be going into the grounds and basis for appearing for the court.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
My Lord, before Mr. Kibe moves on that part, are there other files, especially file number petition E5 72, 2024. Zero.
Okay, ladies and gentlemen.
Before the bench.
We'll adjust because we are facing technical difficulties. So bear with me, ladies and gentlemen, brothers and sisters, as we continue to hold on. Just give me a second, guys. I'm about to set it up so we can get a clear, more secure way of doing this, because I think Ruto is doing that thing. So subscribe to the channel if you see this is your first time, and like the video as we continue with this. All right, just bear with me. I'm about to get back to the trial or the hearing, so to speak. All right, we're in there. So here it is. Hold on. Just a moment.
(2024), and it came up before Honorable Justice Mwamuye, who gave directions that it will come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench issues as the issues that were consolidated and I'm appearing in person with Ms. The bench was constituted, so we expected that the matter would be mentioned together with this one today. Thank you.
respect, and the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024. That is the file that was called out. And in order for the record
Ladies and gentlemen, brothers and sisters, I'm sorry for that. We are being under attack, but we are back.
E565. So those are the three matters which are before this court for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files applications for this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them, maybe they are yet to reach us, but for the purposes of today's hearing, we have these petitions or applications.
We also appear in P015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kirugwea is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kirugwea, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file with the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing?
Yes, let me deal with the 22 of 2024. That's all I'm only saying. I have had the directions of the
orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. Those applications were filed online. Those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge. Just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet, and that we will go back and find this. All the other petitioners whose concerns are valid, perhaps those files will now be before the bench formally.
Yes, Madam, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make this clarification.
Which was consolidated in the where with E014. Let's take a run on that file.
It was not part of what was called. I've not had perhaps in court. Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
But when Justice Mrima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
My Lord, may I say something?
Let me answer you. You said that records speak for themselves. And for record, matters which came from Karugoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11th by Judge Richard Mongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014, and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make order to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we will now raise the issues that we want to raise, particularly arising from the issues in Kerugoya. And I do not know.
Proceed and take quorum on it. They were consolidated, so we don't take further quorum on this one.
The Attorney General, I don't know, I have indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had read your subject to speak. It doesn't override my right to represent my clients.
I'm repeating it.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
My Lord, I wanted to say that the only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders. We have E15.
E15 has
conservatory orders, but E13 and E14, although from Kerugoya, They were filed before impeachment and they had no conservatory order.
Yeah. I hope I be heard without my lords, my lord, I'm leading the number of advocates in this matter from Kenyaga. T015. Yes. Yes. My lord, the clarification that I seek to raise emanates against this general background. The first one, my lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client, letter to the Honorable the Chief Justice, which has been placed on record in an affidavit, in an application before you, amongst other things. Practice. Sitting would be convened for purposes of hearing the executive and
Ladies and gentlemen, bear with me. I'm having streaming problems, but I will get it together. So here you are. Okay, hold on. Let me just get this straight real quick. Like the video, ladies and gentlemen. Like the video, share, subscribe, comment, and we'll get back on track in a few minutes. Okay, here it is. Here it is, Daddy.
have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed by law, the issue is this. We expect a notification in writing that these judges have been appointed and they will seek on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would
in an application by the executive be convened on a Saturday. That is a substantive issue because of the second reason that our background that we are giving. But under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lords, under the
Ladies and gentlemen, I'm sorry. I am being attacked. My live stream is being attacked. So
two is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the order that we are here before previously. But now, pursuant to my instructions, that practice of the former constitution, where the executive enjoys special privileges. Number two, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the 190 and with a clear conscience. Two things. Well, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number two, my lord, is this, the issue of bias. And this is bias by the honorable.
I think, Mr. Mungai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you better.
That is the other issue that does not have to do with those prayers. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment. My Lord, there are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? There are an express order of the court that has not been set aside. The question would be this: for purposes of good order and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important is this: the matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord,
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done. But if you have an issue with that, please don't make a generalized complaint.
Well, this is not raised. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
Hear you. My lord, sir, just to add on what my learned friend has submitted on, I will give.
With the permission of the presiding, I wish to say that you can sit down. I wish to make this clarification. The matters which are before us today, the 3 matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench. Thank you.
Allow us to worry when we have grounds.
Senior Counsel Mute and Counsel Negua. You know, when you argue the way Mr. Mugabe has argued that court start on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai. Let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
In E015 in the report. We haven't said our piece, and Elisha Ogoya will be making
But may not do give us, these are very weighty matters. This E015 in Kirogoya. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? Permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the President that will be set for the removal of Deputy Presidents in future and the removal of President in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be ordered. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
No. There's no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, your lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, your lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, your lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Where did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, your lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, your lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, your lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and the other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, your lordship, those matters were equally satisfied as urgent and raising heavy constitutional matters. When I looked at your orders, your lordship, that you issued to serve on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling the bench. We are called, like in the lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, your lordship, most respectively.
For the record, Dr. Kamoto for the field respondent in issue 15. I believe the reason
Am I audible? Crap. And we're having trouble with the stream. As I say, I've been ambushed here, but we'll fix it. We'll fix it. We'll fix it. Let me fix it real quick. Go back to the issue at hand. Please don't forget to like the video, share, like, comment, subscribe.
Hello, for the first interested party.
I was about to interject when Mr. When Council, Mr. Not like the other one. Yes, whatever was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which application can only come after I have spoken. We are now making an application. You respond. What is it that you want? Your Lordship, permit me to make an application under the Mutunga rules. That following the disclosure of the court this morning, that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 546. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry, we are constrained to interject, seek your guidance. My name is making an application before the bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this note. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the BCJ being made parties to that application, and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds reason of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ, so that they have a chance to respond to these insinuations. I suggest again, I beg the court, I'm encouraging a counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may. Yes. Yes.
My lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and Edward and my friend Kibe, is that you are taking the court for a long ride and we are ending up wasting a lot of time. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you say?
My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Rigathi. I'm acting in person. We filed an application for certification of LSC on the 8th of October, 2024. Before this bench was impaneled on the 14th of October, 2024. Unfortunately, some of the cards we were seeking have been overtaken by us. I looked and today, as I've heard, our application has not been placed before you, and we're just concerned that our application will once again, investment and once again overtake our application. My lords and my lady. So we're asking with the kind of indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
For the 15th of the party in 15, I just had for 1 minute only. I know just ask an important question. How do we move forward? But the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. having said that, my lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here.
And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Rigathi, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that lawyer applied for an adjournment? Because he's saying, and perhaps rightly wrong, that even the recusal application comes after the examination of the question when panel. If that is so, they normally leave court, they may leave, they left the Senate, they leave court. Let them say whether they apply for adjournment.
Is that remark, they normally leave court, they left Senate, palatable in this court, my lord? I need that answer first. No, is that remark palatable for my lord and my lady? My lady, because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with doing the remark. But the point is, it is a veiled application for adjournment. Because Mr. Moya is saying that the court must address the question of empanelment before the recusal.
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing.
No, my lord, you must withdraw.
I withdraw the remark.
Thank you so much. Thank you. Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and been my mentor of many years. I have no disrespect for him. I just have my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Kibe Mungai, and learned colleague, Mr. Ndegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Rigathi Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. They'll have a determination on that question. I humbly plead.
Speaking for too long. Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. They actually knew of it, and they would have found out the letter which was written this morning, which it was written on the 20th of October, as actually one pertinent question disposing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told, that as we do in the parliament, you go around in circles to waste time so that the motion possibly is defeated by a fluxion of time, which is what they're trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleague, the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
Okay. All right. All right, ladies and gentlemen, brothers and sisters, friends, enemies, comrades. So it seems. Sorry. So, can you guys hear me? Thank you for listening. I'm sorry I was having time. I was really being attacked. There's somebody's trying to sabotage my stream, but we'll soldier on and we shall discuss these issues. So anyway, on the petitioner side, or let's say on the deputy Gachagua's lawyers, the issue that they seem to be raising is the empanelment of this bench judges that were actually listening to this their claim, the case, whatever, and they're basically arguing that they just found out that it was the deputy chief justice that appointed them to hear this case, and they're arguing that under Article 165 4, it basically says that it is the chief justice, who is supposed to, choose a panel of 3 judges or whatever the case is to oversee or hear this case. So they're arguing that procedurally, this is not what was supposed to happen, basically. On the other side, the lawyers for the Senate, the lawyers for the Speaker, the lawyers for the National Assembly are arguing that that should not be an issue, that those lawyers, the Ndegwas and Sogo are just wasting time, that the Deputy Chief Justice can actually appoint these judges because he's in effect deputizing the Chief Justice role if the Chief Justice is not available. So it shouldn't be an issue. And they're just, pointing the finger to the other side, saying that you guys are just wasting time. You want to prolong this whole idea. So anyway, both of them, they went back and forth. And basically the judge said that if the issue is about if these judges, what do I say? If these judges, they're going to rule on if these judges are qualified to sit and listen to this case, Gachagua's case and Nani's case, Kindiki's case, they will rule on that issue, on that application when they can come back in an hour. So they'll come and we'll know then the way forward after an hour. They'll say if they if they'll go ahead and hear the case or not, because that's the issue that has come up today. Because like I said, just to reiterate, the lawyers for the deputy president, ex-former best deputy president Gachagua, they're arguing that these judges shouldn't be listened to this case because the person who was supposed to impanel the judges to hear this case was the chief justice and not the deputy chief justice, which is the case. So they are going to hear about that, and Sogo also made the case, we don't have to have, they don't want to face a case where these judges go ahead with this, hearing this case, then later on they have to, recuse themselves because of the procedural anomaly of what's going on. So we'll know in an hour what will happen. Again, for those of you who are wondering what the Constitution says on that 165, Article 165, the 4th statute, yes. Let's see if I can find it here. Article 165 of the Kenyan Constitution. That is what they were actually quoting. So, yeah, we'll be hearing from the court an hour from now and see what's going on because, it's very interesting, to be honest with you. Let's see, and we'll listen to the panelists on different whatever on what they're saying. Okay, so here it is, ladies and gentlemen, brothers and sisters, just to help you out on the issue of empanelment. Empanelment, for those of you who are wondering, is just basically the Chief Justice will choose the judges to hear a particular case. And here it is. Let's just read the article here that Ndegwa is dealing with. If you can see, this is Article 165. High Court deals with the High Court. And this, the fourth statute there, it says, any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3 assigned by the Chief Justice. Okay? Assigned by who? Let me just make it bigger here. As you can see, this is where I'm reading at. Can you see that? If you can see, follow me. You see the cursor there. It's saying any matter certified by the court as a raising substantial question of law under Clause 3B. What's Clause 3B? 3B is right here. Jurisdiction 3B. If you can see 3B, 3 is right here. 3B is dealing with jurisdiction to determine the question whether a right or fundamental freedom in the Bill of Rights. Okay. Okay, so 3B or D. D is right here. Jurisdiction to hear any question respecting the interpretation of this Constitution, including the determination of the question whether any law is inconsistent with or in contravention of this Constitution. 2, the question whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or contravention of the Constitution. Or 3, any matter relating to constitutional powers of state organs in respect to county governments and any other matter relating to the constitutional relationship between the levels of government. And 4, Roman 4, that is, a question relating to conflict of laws under Article 191, and E, any other jurisdiction, original or appellate, conferred on it by legislation. But anyway, again, Article 164, which the petitioners, the Ndegwas and the gang on Sogo are making fuss of, which, I mean, they're making a good case. It refers to, here it is, any matter certified by the court as raising a substantial question of law under Clause 3B or D, which I just read, shall be heard by an even number of judges, being not less than 3 assigned by the Chief Justice. Again, they're saying this because they just found out that apparently it was the Deputy Chief Justice who empaneled these judges. So they're arguing that these judges are not empaneled properly, so they can't hear this case. But again, the judges just came in after hearing everybody out, these lawyers, they say, okay, we've had enough. In 1 hour, they will determine if they will go on to listen to the case or they will not. And that will mean that the matter will go back to the Chief Justice Koome, who will again empanel 3 judges, not more than 3, an even number, not more than 3. So we'll see what happens in an hour. We are waiting to hear from the people from different we hear from, let me see. Okay, as we continue, ladies and gentlemen, just if you don't mind, like, share, subscribe. We'll try to see what's going on in. So that's the case. That's one of the issues that they're going to discuss: conservative orders and all that good stuff. Good stuff. Good stuff. So much to unpack, but the question is, again, the question will be whether this court will be able to listen to the court. This. Let me see. Hold on, guys. Let me just find somewhere where we're gonna address this issue that's going on. Just give me a. Okay, here it is. Let me just. I don't know why they.
Kudelay kwa sababu ya hizi technicalities, alafu tena kwa sababu Wakenya wanangojea hii story inaleta
hali ya mshike. Lakini Daniel, tumeona hawa hili jopo likijaribu sana kuwarai mawakili wa naibu rais waweze kuweka mambo mengine chini na waingilie kwenye swala zima. Sijali, msiogope, tunasikiliza pande zote, sisi ni wanasheria pia. Hivi basi inaonekana pengine msukumo umetoka sana upande wa naibu wa rais aliyeng'atuliwa Rigathi Gachagua, kando na kutoka kwenye jopo hili la majaji watatu ambao wanaomba wajiondoe.
Okay, unajua mimi naiangalia hivi, kama unakuja kwa, if you're coming to the courts, lazima uweze kuprove.
Naam.
Kitu ya kwanza, kama kwanza ukuje, if you're coming to equity, you come with clean hands. Lakini ya pili, kama unakuja kutafuta justice kwenye koti hiyo na una persuasion eti hawa jaji tayari wako na bias, you must be able to prove. I think from where I sit, lazima uweze kudhibitisha ya kwamba hawa judges ina way yenye kila mtu yenyewe ataona hawa judges ni kweli, either previously wamejipronounce on this matter in a biased way, ama actions zao previously zimeonyeshana ya kwamba wanaegemea upande. Lakini kuchallenge capacity kuconstitute bench, nafikiri hiyo ni administrative katika operations za judiciary. Kama Chief Justice wa Kenya hayuko, it's obvious ya kwamba hizo duties ambazo ziko kwa Chief Justice zinateremka zinaenda kwa naibu wake. Ya mwisho, on that same point.
Kwa kifupi tu.
Yes. Nafikiri kando na ile ambayo tunaona ikifanyika kule chini, nafikiri ni vizuri niseme hivi, kulingana na mimi, kwa sababu hii ni process ambayo inahusu mwanasiasa kutotakikana katika siasa. Ninafikiri this is a process, hata ile process ambayo itafanyika kotini ikiendelea. Nafikiri what is more important for Kenyans is to understand ya kwamba implications ambazo zinatokea hapa kama president kuenda mbele.
Asante Daniel, bado tutaendelea. Tunachukua mapumziko mafupi tu, mtazamaji wangu, lakini tukirejea tunakuja na taarifa zetu za NTV Adhuhuri. Vilevile kumbuka tunao wageni katika studio ambao wanaendelea kutupa mtizamo na kuchanganua mambo jinsi yanavyochipuka pale mahakamani Milimani. Kwa sasa tunaenda katika mapumziko mafupi tu, usiende mbali.
Yeah, we'll keep on following as we wait for the hour where the court will decide if they will keep on listening to the case since they've been challenged by the Rigathi Gachagua's team as to whether they're qualified to listen to this case because they've been impaneled by the Deputy Chief Justice, which is contrary to Article 165(4), which says that the Chief Justice is the one who's supposed to pick a 3-panel judge, not more than 3, not less than 3, an even number. And that's the work of Koome to do that, not the Deputy Chief Justice. So that's why the petitioners here in this case are challenging the validity or the procedural anomaly here by the fact that these guys were impaneled by the Deputy Chief Justice. So we wait to see, as we had them say, the matter will be known in an hour's time, whether they can go ahead and hear and rule on the matter. I think the matter was about the conservatory order. And also, basically deciding if, Kindiki should go ahead and become the deputy president or former deputy president is done with. So, if you're joining in, ladies and gentlemen, brothers and sisters, we're just following up with what's going on. The courts, the 3-panel courts, Justice Mrema and the rest, they've been challenged by the by Senior Counsel Ndegwa and the rest, and Sogo and the rest, who have said that, hey, listen, you guys were picked by the Deputy President, not the Chief Justice. Sorry, you were picked by the Deputy Chief Justice, not as per the Constitution, which requires the Chief Justice to pick not less than 3, an even number panel of judges to see over this matter. So they say, okay, we've had enough. We've had all the arguments. We'll be back in an hour and we'll make the decision if we are going to go ahead to listen to this case or we are going to recuse ourselves, and the matter shall go back to the Chief Justice to pick another 3-member panel, or not less than 3-member panel, an even number of judges picked by Koome as Article 165(4) requires, and then it shall go on. So if it happens that way, this case will be probably. I foresaw that this thing will be dragged and dragged and dragged and dragged, but at the end of the day, by all indications, former Deputy President Rigathi Gachagua shall remain in his seat, will retain his seat as the Deputy President. I just don't see how. There's so much, too many reasons not to, allow Kindiki to be the Deputy President, the new Deputy President. There's so many reasons not to. He's not qualified because the IEBC did not vet him. He was never a member of the UDA from the last 6 months. It's just a bunch of stuff that I don't see. It will be something. It will be crazy if they actually allow Kindiki to become the Deputy President. It's just not going to happen. I just think this thing is being dragged. Ladies and gentlemen, if you're not aware, also Tony Gachoka versus Adani. The case is in the courts. I have no way of getting the link to that. The major media stations are not reporting on it. So we'll find other ways. We'll just follow the Gachagua story and see where it takes us. The course is in recess for an hour at least, but they should be back and they will rule on whether they can go on. They'll rule on whether they can go on with the story, with with the matter, okay? So do me a favor, ladies and gentlemen. We'll be right back in about an hour to follow up with the courts and see if this case will be or should, right? Okay, hold on 1 second. Let's get 1 minute. Just give me 1 minute here and we'll be all right. Hold on. Okay. Just a minute. Just give me a second, guys. And as we continue,
Let the record show that counsel appearing for the Deputy President today before this honorable court appear at the protest. As I say, the basis will be elaborated later. I appear, or Muite for the record, I appear with my colleagues, Tom Acharya,
which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you're all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today.
And the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these two files. So let that not be an issue here, please.
And that is at the Milimani High Court. But now we join our reporter, Fred Kagonye, who has been following up this matter at the High Court. Good afternoon to you, Kagonye. Now, very well today, the matter has started at the court with a 3-judge bench listening to the arguments from both sides, with President William Ruto, the government today, saying that they want the matter to be taken to the Supreme Court. Just take us on the arguments that happened in the court, Kagonye.
Thank you very much, Aseto. We are coming to you live from the Milimani courts, where the case challenging the impeachment of Deputy President Rigathi Gachagua was set to start today. It started, but the petitioners, there were several cases that were filed at the Kerugoya High Court, which were consolidated, and a 3-judge bench consisting of Anthony Murima, Eric Ogola, and Justice Frida Mugambi was constituted to hear these petitions, which are, number one, challenging the impeachment of Deputy President Rigathi Gachagua, and then number two, there were orders that were given barring the Interior CS, who has been nominated as the replacement of Rigathi Gachagua as the Deputy President, from being sworn in. Now today, when the parties appeared before the 3-judge bench, among the many issues that they have raised, that have been raised by the petitioners, is the constitution of that bench. Their argument, led by Counsel Kibe Mungai, who's representing one of the petitioners, he was saying that this bench was constituted, was rather empaneled by the Deputy Chief Justice, yet Philomena Mwilu, yet this should be done by the Chief Justice Martha Koome. And on the respondent side, led by National Assembly lawyer George Murugara, and then you have the Senate lawyer and Kisumu Senator Professor Tom Jenda, and Peter Wanyama, who's representing the Senate Speaker. They argued that Philomena Mwilu is Martha Koome's deputy. In Koome's absence, then she can assume her roles and discharge the duties which, on a normal day when the Chief Justice is available, she or she is supposed to discharge. So that is what has dominated this case from morning. And another application that was being made by the petitioners through lawyer Ndegwa Njiru was that this 3-judge bench is biased, because remember, there's a case that was seeking to stop the impeachment process, and it came before this judge, and it did not succeed, because to be remembered, the Deputy President filed not necessarily through himself, but a number of cases were filed seeking to stop that whole impeachment process from the National Assembly all the way to the Senate. And among the other things that they have argued is that that 3-judge bench is biased. So the Deputy President's lawyer, that is Elisha Ongoya, said, and he proposed this to the courts, that before we proceed to any other issue, the issue of how the 3-judge bench came to be should be decided upon, and the presiding judge told the two sides to make that formal application, that is the petitioners to make that formal application which challenges the constitution of that bench. And then for the respondents, in this case the National Assembly, the Attorney General, the Senate, and the Deputy President himself, who is being represented by Dr. Adrian Kamoto, to file their responses, and then they will make their ruling at 2 p.m. on whether they have been well constituted. Aseto.
We discussed matters to the empaneling of the 3-judge bench and whether it is legal. There is also the matter that the president has filed, that is matters to do with the matter should actually be heard by the Supreme Court. Has that been canvassed in the hearing earlier in the morning?
When the lawyers were making their submissions, the president's lawyer, that is Dr. Adrian Kamoto, made that known to the court that the matters that they are presiding upon, the matters that they are hearing, are reserved of the Supreme Court. But looking at the Constitution, the Supreme Court has 2 roles, that is to issue advisories to either the national or the county government, and number 2, to preside over a presidential election petitions. But that issue has not been argued by the two sides. It's only that when he was making his submissions, he raised that issue. And the presiding judge was quick to stop any more contributions or any more presentations before them, saying that if that was to happen, then the arguments would come from the petitioner side, from the respondent side, and would go on and on and on and on and on. So he refused to give any other chance to anyone to continue making their submissions, and that's when they made the move to move the court the proceedings to 2 p.m., where after the formal application has been made by the petitioners, and then a response has been filed by the respondents. Then at 2 p.m. they'll come back and then they'll make a ruling.
Fred Kagonye there joining us from the Milimani High Court, who has been following the case that has been filed by the impeached Deputy President Rigathi Gachagua. We shall be heading back there at 2 p.m. to listening to the rulings that will be given by the three-judge bench. But until then, let's take a short commercial break. We'll be back with many more stories making headlines.
All right. All right, ladies and gentlemen, we'll be back in an hour when they come back with the decision whether to go on and listen to the issue, or will they take it back to Gome to empanel a new judges to listen to the case. So subscribe, like, share, comment, and I'll see you guys later. Peace and blessings.